Good morning, ladies and gentlemen. I want to thank you for coming back this week, participating again in the trial. I know it's been a long road for everyone, but we're getting close to the end here. And what I wanted to say, just to start this way, is that everyone on the panel spoke during jury selection. And when we were talking about the death penalty, one of the things I asked and tried to focus on was that if we got to this point, would you still be willing to give the defense a fair shake at getting a life sentence? And everyone said, yes, I can do that. And so I am asking you to draw back on your memory and the oath that you took as a juror. Please remember that you did assure the defense you would do that. Now, I'm not saying you have to agree with us, but I would ask, out of respect, that you at least give us the chance to present what we need to present and make our arguments. You know, here we are, just where we didn't want to be. And we had to talk about this before the trial even started, because sometimes this does happen. And there's two things that I want to get off straight right here to this jury. Okay? Number one, the defense respects your verdict. We don't necessarily like it. It's not what we wanted, but we respect your verdict. You worked very hard, stayed out for a long time. No one knew what you were thinking. But that's what it is, and so we're accepting it. But the other thing that I want to point out, right off the bat, when we start this penalty phase, is that the information that the defense presents to the jury is not presented as some type of defense or some type of excuse for the crimes that you convicted him of. Not what it's about. You've made your decision. It's not a time to put forth another defense or offer some things as an excuse for what you've convicted him of. But perhaps it could serve as some type of explanation as to how we get to this part, and could provide a path forward for a juror who wants to vote for life, looking for a reason. We're going to give you some. We are here humbly to ask for your mercy. We don't think that Lewis should be given the death penalty. We believe his life is worth sparing, and we are at your mercy. This part of the trial, I would suggest, will be different than the other part, in the sense that probably won't be as many objections and not quite as ramped up. Should go very smoothly. But please recall this, ladies and gentlemen. No matter how many aggravating factors the state proves beyond a reasonable doubt, and if you find that these aggravating factors outweigh any mitigation the defense puts forward, under the law, you never, ever, ever have to vote for death. And you don't have to tell anyone why. You just do it. It's not a group decision like it is in the first phase, where you all have to come out with unanimous verdicts. That's not what this is about. Each, him and her, you have your own personal decision to make. Of course, you discuss it with the other jurors, but it is a very individualized vote. Now, what we believe the evidence will show during the penalty phase portion of the trial is that there are many, many what we call mitigating circumstances surrounding Lewis and his life. What you will see through testimony and documentary evidence is that Lewis has had a history of multiple hospitalizations for various different things. He has a history of suffering from seizures, what they call grand mal seizures, dating back to as early as perhaps 9 or 10 years old. He has a history of psychiatric problems dating back to his perhaps as early as 3 or 4 years old, being treated at a mental health hospital in New York City called Mount Sinai. He has a long history of multiple head injuries that you're going to hear about. Some we have documentation, some we don't. He has suffered a number of concussions through his life. When he was approximately 10 years old, he was hit in the head with a baseball, a hardball, to the point where it knocked him out, and he went into a seizure, major seizure, and was taken to the hospital. This is just a flavor of what we're going to present. I'm not going to tell you everything right now. Now, Lewis wasn't a good student, right? And what the evidence will show is that he was always in special ed classes his whole life, and he only made it to the 9th grade and dropped out. We do have some school records. Others have been destroyed over time. We will be presenting to you doctors, 3 of them specifically. You're going to hear from a doctor named Dr. Eric Mings, and he's a psychologist. And he did some work for the defense. And he's met and evaluated Lewis, made some findings. The other thing he did was he put him through a battery of neuropsychological tests. And the result of those tests prompted him to recommend further examination. They raised some red flags, not just oral or written test. Recommended that Mr. Toledo receive an outside medical test from the jail facility. He went for what's called a PET scan. And what they did there, he was transported to a facility, and he was injected with some radioactive sugar, put in a machine where they did a scan, a 3D image scan of his brain. And you'll hear testimony that the scan showed that his brain is in fact abnormal. You'll hear from Dr. Holmes. She's a specialist in certain disorders, psychiatric disorders, bipolar, and other personality disorders. And you'll hear testimony from her about her meeting with Lewis, her review of certain records, these disorders that are very well documented, going back years, have affected him within his life and interpersonal relationships. Now again, I'm going to remind you more than once, this is not some type of defense, not offering an excuse, trying to provide an explanation for how you get in a seat over there facing a jury like you. Now the state laid out their case for aggravating factors, and I'm not going to address them in detail right now. It's something perhaps can be addressed later, but some of these are different than others that they're putting forth as far as what weight they might actually carry, and that's something that you'll have to decide later. But for example, the one about cold calculated, premeditated, well, you've already convicted him of premeditated murder, right? That was the count, first degree premeditated murder. So, what does that really add to that? But we'll discuss those more later. The one thing I do want to spend a little bit of time right here on, though, is this. at some point this morning, I believe, you're going to hear testimony, or not testimony, you're going to hear, well, I don't know, I guess it's testimony, oral word, but family members are allowed to come forward and talk to the jury. Now, what's really weird about it is this. I'm predicting, not wise, great prediction, but perhaps it is going to get emotional in here. And then what the judge is going to tell you after going through that is that when it comes down to this decision over life or death, you don't even consider it. It's not to be used by the jury in any way as an aggravating factor. And I imagine that might be difficult to try to do, but that is the law. So obviously, with all respect that these people deserve, you're going to listen. But then you're going to be told you can't use it later against Lewis to come up with a death vote. So it's just a weird way about it. Nothing the defense can do to stop it. And that's what's going to happen. So what we believe, ladies and gentlemen, is this, that, or what we're asking is you keep an open mind, listen to everything from the state's perspective, and then listen to the presentation by the defense and the doctors, and learn about Lewis Toledo. You know, the state wants you to learn some more bad things about him, and I'm not going to stand up here and say our client's a perfect human being. Obviously he's not. But there are some other sides to the man. And it is important, it would seem to me, that if you're going to make a decision as intense and with the gravity, whether he lives or dies, it would seem to me it would be appropriate to learn as much about him as you could before you make that decision. So I hope you understand that, and give us a shot. And we believe that his life is worth saving, and we're going to ask you to come back with a life sentence with no parole. And remember that, folks, it is no parole. He will, your verdict is already short. He is going to die in prison. He is going to die in prison. The question is he going to do it death row, maybe 15, 20 years after all these appeals, this and that, or is he going to go in there in a little tiny cage and just be miserable for the next 60, whatever years he lives? Thank you.